Hello and welcome to Insight, everyone. I'm Nnamdi Odipo.
And I'm Elizabeth Omori. Thank you for joining us.
Today, the judiciary is in the spotlight. Why is that? And how can the system continue to preserve the sanctity of the judicial arm of government in Nigeria? We shall also have a discussion on the seeming gap between democratic ideals and practice in Nigeria, and how what ordinarily should be considered as imperatives translates to dividends of democracy. Elizabeth?
And of course, we all know that climate change negotiators are already gathering in Dubai for COP28, and Nigeria's participation is very important to us. So we will be analyzing implications and benefits for participation, as well as addressing the vulnerability of some African countries on climate change adaptation.
All right, then, let's kickstart the conversation on the judiciary. I'm fascinated with the discourse on national monuments and assets and how much is being done to preserve and
look into the language issue. We have turned English to become like a pride value in our own cultural values.
National cash transfer is not a COVID-19.
Invasion 1897 was a deliberate
many of these people coming to the urban areas now.
And applications, there are terms and conditions that
of course it is the union of two people, a man and a woman coming together.
My name is Nnamdi Odipo.
And I'm Elizabeth Omori.
You're watching Insights, and I'd like to begin our first conversation on recent events within the Nigerian judiciary and rising perception out there in the public domain, which suggests a judiciary which may be saddled with concerns such as nepotism and corruption. Well, the judicial arm of government essentially performs the same role the world over, and that is the preservation of the rule of law, equity, and justice. I guess the question is that now in doubt in Nigeria, and how can the system ensure the sanctity of judicial craft in the country? Joining me to discuss this is Ms. Nasara Kugo Umar, barrister and advocate, public policy analyst and commentator, and a regular here on Insight. Welcome to the program.
Thank you very much. It's always my honor to be with you here.
It does appear like some of the recent events concerning the judiciary may be a reminder of certain things that have happened in the past. And I'm sure you remember the dust raised by the Independent Corrupt Practices and Other Related Offences Commission, ICPC, in its report some time ago, which indicated that the judiciary is on top of the Nigerian corruption index between 2018 and 2020. We see issues arising from post-election cases being determined by the judiciary, and then complaints from aggrieved parties, and then we see certain slips, whether clerical or not, on the part of the judiciary. Is there a basis for some of these allegations that you think, and should Nigerians be worried that the ICPC may have indeed opened the honest nest years ago, and that the situation was probably not taken as seriously as it should have been?
You are right, because what happened is monumental portrayal of disrespect to the sanctity of the judiciary. The judiciary is supposed to be the arbiter of any dispute within the country, and justice should not only be seen to be done, but should manifestly be seen to be done in any matter that comes before the judicature. Under section 14 subsection 1, democracy, in other words, the people are the custodians of the sanctity of sovereignty in Nigeria. Therefore, whatever you do and you gauge it with the perception of the people, the preponderance majority of which are not satisfied with the quality of the judgment that are coming from our judiciary, then it leaves a lot to be desired about. And apart from that, when you look at the Constitution very clearly under section 36, talking about the equality before the law, you go there in order to get justice. But in a situation whereby justice is shredded away, on the altar of some considerable technicalities. In Nigeria now, it has virtually become a tradition whereby the solidity of the law is normally taken in abeyance in preference of some technical things that should be done as the basis upon which judgments are given. This thing that happens is really unacceptable, going by the sanctity of the legal profession that claims to be the only institution of the learned men and women. And at the same time, where it is expected that judiciary, or rather justice, should be the last thing a common man should expect. And then when you see these type of things and you see errors that are uncondonable, for something to happen of that magnitude, definitely it is uncondonable. Then you need to go back and find out the quality of the type of people that are adjudicating over our matters.
Quality.
Then number two, apart from the quality, you talk about the system itself. The system itself that allows technicality, superiority over solidity of the law. And at the same time, you look at even the method of the recruitment of those judges that are supposed to be there, vis-a-vis what is the constitutional provision regarding what factors should be considered. In those days when somebody is to be appointed as a judge, the processes will be kept surreptitiously, different from him, not allowing him to know about it at all. People will go there, the security agencies will be allowed to really investigate his background, apart from his background, his etiquette, apart from etiquette, his degree of knowledge of the law, apart from the knowledge of the law, the experience, the maturity of mind, the level of his dexterity when it comes to the matters of discipline, matters of patriotism, matters of nationalism, matters of anti-corruption stand regarding the sanctity of the purity of the mind of the judge. All these factors are normally coming into play. But over the years, there are a lot of accusations regarding, say, whosoever wants to become a judge should first of all prepare himself to be anointed by somebody who is a serving judge. You cannot be a judge in your own cause. You cannot be the one to determine who will be your own successors. But in Nigeria, that appears to be the decision. You will see children of the judicial officers are the ones that are making up the list. They are brothers, they are cronies. Those that they have one affinity or the other affinity with the judicial officers are the ones that are making the list. Any society that decided to jettison competence, quality, credibility, integrity, and morality, then definitely it is a doom that we are expecting.
I mean, you've thrown up quite a bit here, and these are issues I would like to take you up on. I mean, these issues are key. You've talked about quality, you've talked about the system, and yet again you threw up the issue of, I mean, it all begins perhaps from the recruitment process.
Yes,
we'll talk about all of these. I tell you, I mean, down the line, but. In talking about some of the issues that we've experienced of late within the judicial craft in Nigeria, and then we've talked about the clerical errors and all of that, there is again another issue that I consider quite germane, and I realize that upholding the rule of law and respecting the sanctity of ongoing court cases is vital to maintain public trust in the judiciary. So a situation where we have even lawyers taking out full advertorials on newspapers to make opinions on ongoing legal matters before a judge. Isn't that considered a clear breach of sub judice principles? What are the repercussions for such undue interference?
Well, it's not an interference as such, because when you look at it carefully, even if matters are taken before the National Judicial Council, which is the apex body charged with the responsibility of measuring the degree of moral rectitude and other things on the execution of the judicial officers while on the bench. When you look at it, it leaves a lot to be desired. How many of them have ever been penalized? How many of them have ever been sanctioned on account of doing one wrong thing or the other over the period of years? So if you look at it, then you will not be surprised, because the failure of the NJC and indeed the judicature as a whole to be sanitizing the members and at the same time inflicting penalties on them, these are the things that have really brought it about for it to be like it's a tradition. Whatever you do, you get away with it. Look at, for example, this very serious, unprecedented type of professional breach, and then you call it a typographical error. Which typographical error will do that? And in so many places there, the submissions are there, and then you call it typographical error. If it's just a mistake of an alphabet or a mistake under a word or just one or two, you can call them typographical errors, but not something that has to do with fundamental statements, fundamental stipulations regarding positions, regarding matters that have to do with even payment of penalties, regarding absolvance of offenses against whosoever is being accused. So all these things are decent. The important thing is that this is a torchlight that has really, lightened the directional compass of our judicial process. It is left for members of the judiciary to really think about how they can sanitize their own good image, and then how can they come back, roll the good image of those days. Remember the immediate past Supreme Court judge that left the decision, what he said. Remember too what happened last year when judges of the Supreme Court gang up against the Chief Justice of the Federation on accusations of, very serious corrupt accusations. But at the end, that thing was swept into the carpet because you have not had anything.
Can I read you something from May 2022? And this was something Justice Ejembi Eko, a retired justice of the Supreme Court, said, when he was referencing the corruption and indiscipline, which he says pervades Nigerian judiciary. And this was in reference to, and I'm bringing this up because of what you said about the National Judicial Council. Yes. And this is what he said, and I would like to quote him here. He said, with all deference to the NJC, the punishment falls short of the expectation of the public that these bad eggs should have been broken or smashed or exterminated to serve as deterrent. He said, and this is quoting him as well, when the punishment for an outstanding bad and outrageous conduct is far too lenient, it encourages impunity and or repeats by others of arrogant and atrocious misconduct. He ended with saying, is it to say that there is double standards on the part of NJC in handling some of these issues, or NJC is more like it's like a bulldog without teeth or a bulldog without bites? Yeah.
Now, NJC really, it has failed the expectations of the citizenry when it comes to the matters of sanitization of the judicature generally. NJC has failed, and I do not see the entire gamut of the legal profession needs very serious revolutionary sanitization. Sections 230 to 304 of the Constitution should clinically be x-rayed so that certain things should be infused there, certain things should be removed there. For example, all these political cases, it is an anathema for you to be exposing our sacred judges into all these cases. All these political cases establish election offenses court, establish it as a court of independence, as a court of summary trial where you will go within a period of 4 weeks, maximum 6 weeks, you give judgment, as a court whereby you bar the possibility of having any appeal. They are going into regular courts. Let the regular court be discharging their own decision. All these things that have to do with the governmental something, bureaucracy, all these things that have to do with matters of corruption, establish an anti-corruption court. Let it be the one to be dealing with that. And let, including the judges of the Supreme Court, let them fall within the jurisdiction of this particular court. Let it be an independent court of itself, and there will not be room for appeal. There are many things that requires to be done there to sanitize the decision. For example, judiciary, even the Supreme Court itself. When you look at the Supreme Court there are virtually, I think, only 2 courtrooms there in the Supreme Court. Courtrooms for appeals that will come up with various, look at the number of the high courts we are having. You have almost 1,000 high courts. Their appeals there goes to the Court of Appeal, the 6 judicial divisions of the Court of Appeal, and then from there they come to the Supreme Court. At the end you will discover congestion of cases because there are so many diversionary things. Any matter that involves government, any matter that is political, any celebrated corruption matter, the end road of it is the Supreme Court. By the time they are concentrating in that, you will discover it will be almost impossible for you to file a case and get it listed within a period of 20 years because of the congestion of regular cases there, because the attention of the judges there is more on these type of cases that are this. Therefore, the Supreme Court, to my opinion, should be unbundled, either in two ways. Either you unbundle it, all the common law subjects, you should have Supreme Court of Commercial Law, Supreme Court of Criminal Matters, Supreme Court of Constitutional Matters, Supreme Court of Land Law, Supreme Court of Customs and Tradition, Supreme Court of Marriage and Divorce. You have Supreme Courts like this separated, so on the basis of which any matter that's come should straight ahead go to that court. And then the government should be prepared to recruit more judges to really take care of this adequacy. The second option is that decentralize the Supreme Court. Let there be Supreme Court's division, judicial divisions, just like the Court of Appeal, whereby matters can be dispensed with there and there. But even if you do that one, you need to insulate the Supreme Court away from handling corruption matters, from handling politically related matters. For example, like I said, political offenses court should be established, anti-corruption court should be established, court should be established against all these bandits and criminalities that are really pervading the length and breadth of the country. There should be a court for trial of anti-terrorism court. You should establish it. Then miscellaneous offenses court. By the time you establish these independent courts, then you'll give the latitude for the Supreme Court to really concentrate on the basic things that will be coming on appeal based on the demand of the citizenry from the Court of Appeal upwards. But over and above that, the temperament, the mindset, the discipline, the morality, and the nationalistic stand of the judicial officers should be recalibrated. Those that are really not up to the expectation should be booted out, so that competent technocrat, competent legal minds that are really interested in developing the judiciary, interested in making landmarks. There were judges, for example, in the 70s, when you remember them, those that gives landmark judgments that are prepared to even move rocks. Those are the type of quality people that should be brought back, so that the good image of the judiciary should be restored.
And the independence of the judiciary as well.
Independence, I don't so much believe that judiciary should be given absolute independence. Because the independence is
isn't that what the NJC is doing? Having some supervisory, it has some supervisory role.
The independence is one of those reasons why corruption is really having its way into the judicature. It is because of the independence. But where they know that up there they are responsible, they are to subject themselves to some scrutinies or some critical bodies, that DSS is to scrutinize them, the EFCC is to scrutinize them, and they are to be penalized whenever they are found on wrongdoing. So I don't support absolute independence of the judiciary. There should be some checks and balances whereby those that are not meeting the expectations really should be booted out. There should be periodic disciplinary inspection regarding the conduct of the judicial officers in Nigeria.
In fact, you preempted every question I wanted to ask. I did say we were going to talk about the issue of quality, system and recruitment, and you've answered the question. I wanted us to talk about efficiency and effectiveness of the NJC in responding to public complaints. You've also efficiently and effectively done
because
that.
the NJC is made up of the same members. Nemo, Judas, and Kausasua is an internationally recognized principle of law. You cannot be a judge in your own cause. So why should they be the ones to be adjudicating over their misconduct? It's wrong.
This is an ongoing conversation. I mean, the sanctity of the judiciary is key to the survival of our democracy. And I mean, this is a conversation that we'll put on the front burner, and we will continue to push. Nasra Umar Okugo, I would like to thank you so much, barrister, advocate, public policy analyst, and commentator. A friend of the house. I'd like to thank you so much for coming on Insight.
It's always my honor to be here. Thank you very much.
Well, for most people, the issue is not how the Nigerian political system operates within a framework of a federal presidential representative democratic republic, where, of course, executive power is exercised by the government. For a greater number of the masses, the issue, it would seem, is how a greater majority of Nigerians may not be enjoying the imperatives of democracy as well as its dividends, especially when just opposed against what the political class enjoys as benefits accruing from their elevated positions in power. Well, that is what is up for discussion, and my guest is Idris Miliki, Executive Director, Conscience for Human Rights and Conflict Resolution. Welcome to Insight, sir, and glad you could join us.
Yeah, thank you. It's a pleasure to be here.
Okay, so I just gave you like a synopsis of what we intend to discuss, and most people would ordinarily and readily agree that the ultimate test of the value of a political system is whether it helps that society to establish conditions that improve the standard of living for the majority of its people. I talked about China, or China, stands out as an example. It does not practice democracy, but to a large extent, it's one of the most developed countries of the world. So democracy is an ideology, most people would say. In your response to these issues of what I've thrown up, can you speak to, or in your opinion, what do you think determines what the imperatives for democracy are, and what the dividends of democracy should translate to? And who determines what and who does what? The government or the people?
Yeah, thank you. I think democracy can be defined by the process that brought in leadership or representatives. How participatory, inclusive is the process itself. If few persons sit down, even at traditional level, we may not know that there are democracy there. Before people still vote, so that a leader could emerge. Where you have more than 1-2 persons and somebody is to lead, the process that brought in that leadership is what can be described as democracy. True. But if you look at it from the governance angle, from the politics angle, which is what makes many of our people to think that when you talk of democracy, you think people have to queue on the street and go and exercise their right through the ballot box. That is just one miss. Even the China that we have also expressed yourself there, well, I don't know whether you also know the fact that even the Mao philosophy is also democratic. It's about the process of selection. It's about process of leadership.
It is, and I agree with you there.
Yes.
But in this case, it is not the people who determine the leaders in China, for instance.
Who determines the
leaders?
It's
the party. It's the
party.
party.
Yeah. The parties also make up of people. It's about the organization that you subscribe to. No matter the nomenclature we are trying to use, it's about that human beings sit down somewhere and then form a party, like-minded people form an organization, and now come out with a process to say this is how our own leaders will emerge. You can also know the fact that even if you look at the history of parliament that started in the UK several years ago, you also find out at a particular time there was no parliamentary aspect of governance. But for people to have a way of dividing responsibility so that a process can emerge and the check and balances, that is why you have the parliament today. So when you look at dividends of democracy,
yes,
why many citizens don't enjoy dividends of democracy from their passive leaders or representatives is about they were not part of the process that brought them into power. Okay. And that is one thing, because there is no check and balances. When you look at how governors emerge, how presidents emerge, how local government emerge, and even in several other associations where money is a determining factor, that what do we do now? They have given us money, we go there to vote. When the person gets to that power, he or she does what he likes, and not what even the organization that brought that person into power. If you look at the political party system in Nigeria, for instance, how does party emerge? Who are those people who form the party? Who are the membership of the party? And how does the party themselves subscribe to the organization which they thought they believe in? But 1 or 2 persons pay for dues, you are going for conventions. 1 or 2 persons put it in accommodation. So you don't have a say. So when such a person emerges, he's no longer looking at you as part of the process that brought him or her to power. So he decides what he or she wants to do for you and not what you want. Of course, leaders of government have priorities, but what about the need of the people? What about the need of the followers? I think that is what is called is a issue of this issue of dividend of democracy.
So I hear you. And sorry to interject, but I hear you. Does your analysis, or it will seem that your analysis aligns with the argument that what should actually constitute the basis for determining democratic dividends must be based on the extent to which power is being exercised by the people, and through the ability to elect those that will govern them, and the ability to affect the different programs and policies of government, maybe through active involvement in decision making as well. Does that align? Does that align with your analysis earlier?
Yeah, that is simple thing is the fact that you are asking for a mandate. Who give you mandate? You cannot give yourself mandate. So you must be able to marry the needs of the people that give you mandate and your priority. No matter how you think you know it all, Somebody is there around you who also, even if you are a class monitor, you are a leader at that level. What is the process that brought you to the leadership position? You must listen to those who are there to say, look, we want you to lead us. And this is how we want you to lead us. This is what we want from you. And as long as you protect that covenant, that agreement between the two of you, or the other group of persons, they will enjoy the dividend of democracy. It is not about sharing money that you enjoy the dividend of democracy. As you are coming in to ask for our mandate, did you tell us this is what and what you intend to do? Or do you ask us what and what do you want you to do for us? Because you are just a facilitator. In that particular, anybody can be there. For the period you are going to facilitate leadership and governance and representative, you must always fall back to those who put you there as their leader, as their representative, so that they can be able to say, oh, we have put somebody who we think can defend our interests, can promote our interests. And in that process, they enjoy the dividends of democracy if their interests are adequately protected.
Oh, okay, I mean, let's draw a bit of distinction between dividends and imperatives, because there are certain things required of government. I actually understand the paradox of democracy, and I'm sure, like most Nigerians, you clearly do. I don't know, but I happened on Terry Andrews' Odysseus' fallacy of Western democracy in Nigeria recently, and it was an interesting read for me. I wonder how many of our political elites align with these thoughts in that book. It is centered on the presumption that is rooted in the belief that dividends of democracy naturally, is naturally taken for granted in entrenched democracies, more advanced democracies. But it is made into a show, yeah. Some political experts have described it as electoralism, an evolving concept where elections are the main focus for the political class rather than service in the true sense of public engagement. Is this something you align with?
Well, you see, I always want to refer you to a process. Because whether I talk dividend of democracy, emergence of leadership, and whether through ballot or selection, it's about the people around. It's about human beings who want somebody to lead them. And then what mandate do they give you? And what mandate did you seek for? And I think to me that is very, very important. When you look at the environment here, even you look at, if you take it spiritually, it's the same Quran and the same Bible that is obtainable in Saudi Arabia, Israel, and all over the world. But the environment is different. The situation is different.
So why in our case, and this is the argument, and I get what you're saying, but why is it in our case, it will seem, and that this is the argument, and this is what a lot of people are saying, that rather than focus on the needs of the many, we're seeing a situation where our democracy focuses on the needs of a few, and that is the political elite. And that is an argument that is being pushed out there.
It's because it is the few that also determine who govern them. If you look at those who sit down in a political party before the primaries, how does the candidate emerge on himself? It is the caucus in the night that determine and say, this is our candidate. This is the person I am going for. We have seen several godfathers and godmothers that are determined to tell you, we have witnessed it at various levels. This is our candidate. Everybody now queue in that particular contest. So how do you now come in to now assess or prove that person? So it is the few that determine who governs the majority. It is no longer majority that determine. It's another that people say that the majority will always have their way, while the minority will have their say.
And that is one of the paradox of democracy.
It is no longer the issue. It is the few who determine for the majority, and there's nothing the majority could do. There's nothing the majority could say, because when you look at the resources attached to election, for instance, we just had off-cycle election